form of contracts, reformation of instruments, and interpretation. We start with Article 1356. Sabi niya dito, contracts shall be obligatory. Contracts shall be obligatory in whatever form they may have been entered into. So hanggang dun muna tayo. In whatever form they may have been entered into. So going back to our previous discussion, di ba meron tayong napag-usapan na rule na tinatawag natin consensuality of contracts. Meaning, contracts are perfected by mere consent unless of course, if the law or the rules require some other form. Pero as a general rule, consensual ang contract. So, ibig sabihin, the form is not necessary. So, kino-confirm ng Article 1356 yung principle na yon, yung principle of consensuality. That contracts shall be obligatory in whatever form they may have been entered into. Because what is important pagdating sa contracts ay, yan, yung kasunod, provided that all the essential requisites for their validity are present. So yun lang naman ang importante para magkaroon ka ng contract. Meaning, basta present ang consent, present ang object or subject matter, present ang consideration or ang cause or consideration, then meron ka ng contract. So it is not required to be reduced in writing. As long as there is a meeting of the minds, then that's already okay. That is already acceptable. However, sabi ng 1356, however, so balit, kung ang batas daw, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that the contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the parties stated in the following articles cannot be exercised. So, hindi pa natin alam kung ano yon in the right of the parties na tinutukoy niya. Pero let us concentrate sa binanggit ng 1356. Sabi, as a general rule, consensual ang contracts. Ngunit, kung merong batas, when the law requires that a contract be in some form, sabi, meron daw formality na required para siya ay maging either valid o kaya enforceable. Magkaiba yung validity sa enforceability. Dapat sundin daw yung form na binanggit, yung hinihinging formality. Okay. Sa next slides natin, merong mga, kinuha ko yung mga examples, mga halimbawa na nagkalat sa civil code natin. Yun yung ano dito medyo effort, hindi naman effort. Ito yung medyo, tawag dito, how do I consider? Sige na, effort na lang. Medyo effort din siya kasi walang specific na article yung civil code natin na nag-enumerate ng mga contracts na kailangan in writing to be valid. Yung to be enforceable, yan, meron yan. Merong enumeration yung civil code natin ng mga contracts which are required to be in writing to be enforceable. Not to be valid, but to be enforceable. And that listing of contracts which are required to be in writing to be enforceable will be discussed in a future video, particularly on unenforceable contracts. But in the meantime, we will concentrate on those contracts which are required to be writing to be valid. Again, there's no specific provision in the civil code which enumerates yung mga contracts which are required to be in writing to be valid. So, kinuha ko sila. Pinagsama-sama ko ngayon. Sabi ng Article 748, the donation of a movable property may be orally or in writing. An oral donation requires simultaneous delivery of the thing or of the document representing the right donated. Ito na yung importante. If the value of the property donated exceeds 5,000, kapag yung value daw ng personal or ng movable property na iyong dinodonate or pinamimigay ay higit sa 5,000 piso, the donation and the acceptance shall be in writing. Dapat nakasulat siya. Sabi pa ng 748, otherwise the donation shall be void. So malinaw na hinihingi ng Article 748 na kapag ikaw ay nagdo-donate ng personal property na ang value ay lagpas ng 5,000 piso, dapat isulat ang donasyon pati na ang acceptance. Dahil kung hindi ito susundin, ang donation ay magiging invalid, magiging void siya. Walang kwenta, walang silbi, as if hindi siya nangyari. So yun yung binabanggit dito sa example na binabanggit dito. However, when the law requires that a contract be in some form in order that it may be valid, then that requirement is absolute and indispensable. Hindi mo daw pwedeng i-disregard. Kaya siya indispensable eh. Dapat sundin mo siya. 749, in order that the donation of an immovable naman, ito movable, ito immovable, gaya ng lupa, magdodonate ka ng lupa, para daw maging valid ang donation mo ng lupa, the donation must be in a public document. O hindi lang in writing ang hinihingi niya. Gusto niya public document pa. Pag sinabing public document, syempre kailangan mo ng kasulatan bago ka magkaroon ng public document. Ang isang document ay nagiging public document kapag ito ay dinala mo sa isang notary public at iyong sinumpaan sa harap ng isang notary public. It will convert the act of notarization, will convert a private writing or private instrument or a private document into a public document or a public instrument. Yan. Ang sabi ng 749, kung ang iyong dinodonate daw ay isang immovable property gaya ng kalupaan, dapat yan ay nasa public document. Hindi lang basta nakasulat ha. It must be in a public document and you have to specify in that public document the property donated and the value of the charges which the donee must satisfy. Sabi ng next paragraph, the acceptance may be in the same deed of donation or in a separate public document. So, ibig sabihin, yung acceptance din ay dapat in a public instrument din. Okay? So, ano ang effect dito? Validity. Ibig sabihin, kung hindi mo susundin yung mga requirements ng 749 with respect to donations of immovable properties or real properties, then the donation is not valid. It's not valid, it's void, it is inexistent. 804, every will must be in writing and executed in a language or dialect known to the testator. In writing. Sa ang last will and testament, dapat nakasulat. Walang last will and testament sa Pilipinas na valid na hindi nakasulat. So kapag nagkuha ka ng cellphone mo, selfie ka ng ganyan, sinasabi mo yung supposedly magiging laman ng last will and testament mo, hindi siya valid kasi hindi siya nakasulat, binabanggit-banggit mo lang. Nire-record mo lang yung sarili mo. So 804, a will must be in writing for its validity. 1771 of the Civil Code, a partnership may be constituted in any form except where immovable property or real rights are contributed, then a public instrument shall be necessary. The public instrument ulit. Alam niyo na kung ano yung public instrument. A contract of partnership is void whenever immovable property is contributed thereto if an inventory of said property is not made, signed by the parties, and attached to the public instrument. So gagawa ka doon ng inventory ng mga real properties, tapos di ba may public instrument dito, i-attach mo siya doon. 1874, when a sale of piece of land or any interest therein is through an agent, the authority of the agent shall be in writing. Yung authority yung hinihingi, hindi yung sale. Iba yung sale. Yung sale of piece of land, iba yon. Hindi siya covered dito. Ang pinag-uusapan, the authority of the agent to sell on behalf of the principal. If the subject matter of the sale is a piece of land, the authority of the agent must be in writing. Otherwise, the sale shall be void. So imagine yung authority yung kino-question mo. The authority is not in writing. Anong effect? Yung sale mismo ang nagiging void. Okay, that's 1874. 1956, no interest shall be due unless it has been expressly stipulated in writing. So kapag may utangan at gusto mag-charge ng creditor ng interest upon the debtor, then para matuloy yan, para maging valid yan, they have to agree for the payment of interest, and that agreement should be reduced in writing. Without that written stipulation or agreement, then walang mata-charge na interest pursuant to 1956. And last example, Article 2134, antichresis. The amount of the principal obligation and the interest shall be specified in writing. Otherwise, the contract of antichresis shall be void. So ito, yung mga naka-enumerate natin example, hinihingi yung kasulatan, hinihingi yung public instrument or public document, hindi lang bilang requirement na kanilang validity. Kasi kung hindi mo susundin yung nire-require niya na kasulatan or public document or public instrument, nagiging void ang iyong kontrata o yung act, like the donation, nagiging void siya. Okay? Ang sabi dito, balik tayo sa Article 1356. If the law requires, kagaya ng mga binanggit ko kanina, that the contract be in some form, in writing or in public document, in order that they may be valid or enforceable. Again, ibang usapan pang enforceability. That requirement is absolute and indispensable. So hindi mo pwedeng ipilit na consensual ang contract. Hindi. Kung ang batas ay nanghihingi ng formality, then we have to comply with that formality. Okay, what if hindi naman hinihingi? 1357, if the law requires a document or other special form, as in the acts and contracts enumerated in the following articles, the contracting parties may compel each other to observe that form once the contract has been perfected. This right may be exercised simultaneously with the action upon the contract. So, sabi niya, enumerated in the following article, tingnan natin. Sabi ng 1358, the following must appear in a public document. Sir, validity po ba ito? Hindi. Yung mga naka-enumerate dito is not a requirement for validity, but a requirement for convenience. So, convenience lang ang pinapatungkulan ng Article 1358. Mere convenience only. So, acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable, it must appear in a public document. Sale of real property or interest therein, governed by 1403, number 2, and 1405 on unenforceable contracts. The cession, repudiation, and renunciation of hereditary rights. To prove the power to administer property, the cession of actions or rights proceeding from act appearing in public document. Okay? All other contracts where the amount involved exceed 500, again, this is covered by unenforceable contracts. Itong Article 1403, number 2, and 1405 pertains to unenforceable contracts. Ano sinasabi niya dito? Sabi niya, kung meron daw hinihingi yung yung batas, for convenience only, the parties may compel each other to observe that form. For convenience only, not for validity or enforceability. So for example, let's go for example, 1956. Sabi dito, no interest shall be due unless it has been expressly stipulated in writing. Nag-agree sila. O sige, pautang. Si X tsaka si Y, pautang. Sige, pautang magkano 1 million. O sige, agree ka ba? Pautangin kita, agree ka ba na maniningil ako ng interest sa'yo? Sige, agree ako. Kailan mo babayaran next year? 1 year interest. Magkano? 6%. 1 million, so 60,000 yun. Yes. Tama ba? 1 million, 6%. 60,000, agree ka na magbayad ng 6. Yes, may meeting of the minds na tayo. Yes, meron na. Nag-agree na sila. But they did not reduce it in writing. Wala silang ginawang kasulatan. Okay. Wala. And later on, try na naman ningil. Sabi niya, di ba may utang ka sa akin? Sabi mo, magbabayad ka ng interest? Yes. Sabi niya, magbayad ka ng interest. Ayoko nga. Bakit? Wala namang kasulatan yun. Sinasabi mo dyan. Sabi sa 1956, no interest shall be due unless it has been expressly stipulated in writing. Sabi niya, I will compel you to reduce it in writing. Sabi niya gano'n. Sabi ng 1357, if the law requires a document or other special form, as in acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form. I will compel you to observe that form. Is that allowed? No. Why not? Because this requirement is not simply for convenience. 1956 is for validity. The void, ibig sabihin, at the time that they entered into the contract of loan, yung stipulation nila, yung stipulation only, not the contract of loan. Yung stipulation nila to pay interest which was not reduced in writing is void. Diba? For it to be valid, it must be in writing. Since the stipulation to pay interest is void, they cannot remedy it by compelling each other to write it down. Because you cannot remedy something which is void. In the first place, it did not exist. Pag void ang isang bagay, hindi nag-exist yan. So kung hindi siya nag-exist, there's nothing that we can do to remedy a void stipulation. So kung void na yung stipulation to pay interest, you cannot compel me para maayos yung pagiging void niya. Naintindihan ba ito? 1357. For example, 1874, when a sale of piece of land or any interest therein is through an agent, the authority of the latter shall be in writing, otherwise the sale is void. For example, si P, inutusan niya si A na ibenta yung lupa. But the authority of A is not in writing. Eventually, A sold the property to B, the piece of land to B. Okay. Then, B is trying to register the sale. Kaya lang ayaw tanggapin ng register of deeds. Sabi niya, kasi po yung authority ng seller is not in writing. Ganun po ba? Okay. I will go back to PNA and ask them to reduce the authority in writing. Can be compelled? No. Why? Because the sale is already void. Diba? There's nothing to remedy here. Pag void ang isang bagay, hindi mo siya mareremedyohan dahil lang gusto ninyo. Hindi siya mangyayari. Okay, sabi ni Pete, sige na, sulat mo na. Sulat mo na yung writing, hinihingi ng RD, sulat mo daw. Hindi. Walang mangyayari. It is already void, then there's nothing that they can do to remedy the lapse. Okay? Ano po yung pwede siyang i-compel? Okay, so for example, sale of real property. Ang sale, how do we classify a contract of sale? A contract of sale is consensual. Okay? It's consensual or real property. They agreed to sell. Itong lupa ko na ito, bibenta ko siya sa'yo. Okay. Agree, 1 million? Yes, 1 million. Agree ka na? Okay na. Hindi sila nagsalit, wala silang kahit anong kasulatan. Agree? Okay. Ito na yung 1 million. Okay. Ano na lang yan? Anong status ng contract nila? Valid. Valid. Okay, valid siya. Okay, valid daw. Okay. Okay, kung valid na yan, Valid na. Sabi niya, nagbayad na ako ng 1 million. Sulat natin. So, pwede niya bang pilitin na magsulat? Yes, pwede niyang pilitin. Bakit? Kasi valid na yung sale eh. So, hindi ba siya unenforceable? O we will learn later on kung ano ibig sabihin ng unenforceable contract o in the future video. Pero ngayon habang nakikinig ka, sinasabi ko sa'yo, na valid yun. Nagbayad siyang 1 million, tinanggap ng kabila, sabihin niya, wala, hindi mo ko pwede pilitin. No, pwede siyang pilitin. Bakit? Because they already entered into a valid contract of sale. So the buyer can now, na nagbayad na, can now compel the seller to reduce the sale in writing. So, kunyari, napilit niya and trying to register it to the Register of Deeds. Sabi ng RD, na kailangan public instrument ito so that it may affect third parties or third persons. Ganun po ba? Kailangan po ba in public instrument? Can the buyer now go to the seller and ask that they appear before a notary public so that the contract of sale be notarized? Yes, they can compel each other because there is already a valid and enforceable contract. But if there is no valid or no enforceable contract, then the parties cannot make use of the right provided by Article 1357, which what right is that? The right to compel the other party to observe that form. Because you cannot remedy, you cannot correct something which is void or which is unenforceable. Okay? So that's it for form of contracts. I hope you understand. If you have questions, meron palang comment section dito. Lagay nila sa comment section. Now we go to Article 1359. Nakalagay dito, Reformation of Instruments. Never mistake it to be reformation of contract. You cannot reform a contract, but you can reform the instrument. So, ibig sabihin, 1359 onwards, itong portion na to ng discussion, pertains to contracts which are reduced in writing. Kasi may instrument involved eh. Sinulat nila. So what they are trying to reform is the instrument, not the contract. Let us read Article 1359. When there having been a meeting of the minds of the parties to the contract, meron na daw meeting of the minds, ibig sabihin may contract na. Their true intention is not expressed in the instrument. Kasi sinulat nila, ito yung napag-usapan natin, nasulat natin. Pero kung ano may nakasulat nila ay hindi nire-reflect or hindi nakasaad doon sa sinulat nila yung meeting of the minds nila. Meron silang agreement, may napag-usapan na, may napagkasunduan na, pero nung sinulat na, iba na yung lumabas. Bakit iba? Dahil meron daw mistake, fraud, inequitable conduct, or accident. One of the parties may ask for the reformation of what? Not the contract, but of the instrument. Ano ang purpose? For the purpose that such true intention, kung ano yung napag-usapan nila on the meeting of the minds, ay i-express ng instrument. Okay, basahin natin itong pangalawang paragraph. If the mistake, fraud, inequitable conduct, or accident prevented the meeting of the minds, ibig sabihin yung naging effect ng mistake, fraud, inequitable conduct, or accident ay hindi nagkaroon ng malinaw na kasunduan, walang meeting of the minds. The proper remedy is not reformation because there is nothing to reform in the first place. Diba? Hindi mo ma-reform yung instrument, wala ka kayong agreement eh. But the annulment of the contract. If there's no meeting of the mind, or there is a meeting of the mind pero they have not defective yung kanilang consent because of the mistake, fraud, inequitable conduct, or accident, then your remedy is not for the reformation, but for annulment of the contract. Applicable lang ang reformation of the instrument kapag meron na kayong contract. Kapag meron na kayong meeting of the minds. Nagkataon lang na nung sinulat na ninyo, yung kontrata ninyo, gusto niyo siyang ilagay sa isang instrument, written instrument, iba yung nakalagay. Na nagkasundo kayo, bentahan ng manok, nakalagay doon, bentahan ng itlog. Meron tayong pag-usapan eh. Manok eh. Nakalagay doon itlog. Eh, hindi ito yung napag-usapan natin. Anong gagawin natin? Reform the instrument. Kasi there's nothing wrong with the contract. Why would you change the contract? There's nothing wrong. There's already a meeting of the minds with respect to the object and the consideration. So, okay na yun. Let us just correct, reform the instrument so that it may reflect or express our true intention. Correct intention. 1360, the principles of general law on the reformation of instruments are hereby adopted insofar as they are not in conflict with the provision of the code. When there is mutual mistake, para sila nagkamali of the parties which cause the failure of the instrument, again, anong meron? Yung instrument ang namali-mali. To disclose the real agreement, kung meron silang real agreement, may napagkasunduan na, pero dahil merong mutual mistake, mali yung nakalagay dun sa instrument, anong gagawin mo? Annulment ba? Or reformation? Reformation. Because there is already a real agreement. There is already a meeting of the minds. So what you should do is not to annul the contract, but to have the instrument reformed. Okay. 62. If one of the party was mistaken, isa daw mistaken, and the other acted fraudulently or inequitably, in such a way that the instrument does not show their true intention, the former, ito, yung na-mistaken, may ask for the reformation of the instrument. Again, so dito, ganun uli, yung istorya, meron silang true intention. Yung isa, party 1, ay mistaken, party 2, fraudulent. Sino lang daw ang pwedeng mag-ask for the reformation? Yung mistaken. Yung nag-acted fraudulently cannot ask for the reformation of the instrument. Kasi guilty siya. So between the guilty party and the innocent party, it is only the innocent party who can avail the remedy of reformation of the instrument. But again, nangyayari lang ang reformation, paulit-ulit to, magsasawa kayo dito, mangyayari lang ang reformation ng instrument kung meron na silang true intention. It just so happened that the instrument does not show that true intention. If the fraud here or the mistake here prevented the meeting of the minds, then you do not go to reformation. You go to the annulment of the contract. Okay? Kasi voidable yun. Pag mistaken ka or fraud, present ang mistake, di ba? Vitiated ang consent, there is no true intention. There is no may meeting of the minds, kaya lang defective. So what do? You can ask for its annulment and not for the reformation of the instrument. Kasi, again, reformation of the instrument, ano lang siya, formal lang, yung kaya niyang ayusin. Yung papel lang ang pwede niyang remedyuhan. Pero yung napag-usapan ninyo, wala na yun, final na yun. Yun na yun. Gusto lang natin isulat kung ano yung napag-usapan ninyo. 1363, when one party is mistaken and the other knew, alam ng kabila, or believed that the instrument did not state the real agreement but concealed that fact from the former, the instrument may be reformed pa rin. Pwede pa rin mag-reform. Bakit? Kasi meron namang real agreement na. Yun lang importante dito. Pag may napag-usapan na, kaya lang, yung instrument ay hindi sinasaad yung totoong napag-usapan, then don't go to annulment of contract. What you should do is for you to reform the instrument. Okay. 1364, when through ignorance, lack of skill, negligence, bad faith on the part of the person drafting the instrument or of the clerk or of the typist, yung tagagawa, hindi siya party to the contract. Tagagawa lang siya, taga-draft lang siya, taga-computer lang, taga-encode lang siya. And because of the ignorance, lack of skill, negligence, and bad faith of that person who prepared the physical preparation of the instrument, and the instrument did not express their true intention, anong gagawin mo? Reformation na naman. Meron na silang agreement. Ito lang taga-type ang mali-mali ng gawa dun sa instrument. Do you ask for annulment? No. Nag-agree tayo. Alam na natin ang pagkasunduan natin. Yung papel lang ang hindi tugma doon sa napagkasunduan natin. Kaya, i-reform natin yung instrument na yan. 1365. If the two parties agree upon a mortgage or a pledge of a real or personal property, but the instrument of the property is sold absolutely with a right of repurchase, they agreed upon, nagkasundo sila, na mortgage lamang ito, pledge lamang ito, pero nung lumabas na yung papel, naging contract of sale na. Ito ba na pagkasunduan natin? Di ba pledge lang na pagkasunduan natin? Mortgage lang. Oo nga eh. Alam ko mortgage and pledge lang. Ba't ito sale? Oo nga, di ko alam ba't sale yan. Anong gagawin? Reformation of the instrument. Alam niyo na yan. 1366, hindi daw pwedeng ipa-reform ang mga sumusunod. Simple donation, hindi mo daw pwedeng i-reform, hindi mo daw pwedeng palitan ang intention. Not really palitan ng intention, palitan ang instrument. Kapag donation ang pinag-uusapan, or last will and testament, or when the real agreement is void. For example, they agreed na magbenta ng shabu. Nakalagay dun sa kanilang contract, magbenta ng tawas. Sabi nila, di ba shabu yung napag-usapan natin? Pakatawas lang to. Reform natin. Hindi pwede. Your real agreement is void. Walang mangyayari dyan. Again, pag void ang isang bagay, kahit ano pang gawin yung remedyo, wala. Void is void. You cannot put something to it. You cannot color it as valid or represent it as valid. There's nothing you can do with respect to a void contract. Okay? 1367, when one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. So kapag merong party, dalawa lang yan, pwede mo daw gawin. Pwede siyang ipa-enforce o kaya reform. So kapag pumunta ka na sa korte para ipa-enforce yung terms ng isang contract, written agreement, hindi mo na siya pwedeng ipa-reform. You are barred. You cannot subsequently ask. Bawal ka na, pinagbabawalan ka na ng batas na ipa-reform pa yan kung nauna kang magpa-enforce. Pero kung uunahin mo yung reformation, ito yung inuna mo, then okay lang na ipa-enforce mo siya. Ipa-reform mo muna. Pero once na pina-enforce mo na siya without its reformation, then you are no longer allowed by law to reform it if you have chosen to have the terms of that agreement to be enforced. 1368, reformation may be ordered at the instance of either party. So, pwedeng si debtor, pwedeng si creditor, or their successors in interest, yung mga tagapagmana nila, if the mistake was mutual, kung parehas silang nagkamali. Otherwise, upon the petition of the injured party. Ibig sabihin, katulad ng binanggit ko kanina, only the innocent can ask for the reformation of the instrument. Kung mutual yung mistake, then both of you are innocent, considered innocent. But if you are the guilty party, you are the one who caused the confusion or the defect in the instrument, then you are not allowed to ask for its reformation. Only the innocent party may ask for the reformation of the instrument. 1369, the procedure for the reformation of the instrument shall be governed by the rules of court to be promulgated by the Supreme Court. I think this is Rule 63. I will have to check. Or 62. Rule 63. Okay. Rule 63. Rules of Court. Ang tama, declaratory relief. Meron dito, reformation of instrument. Correct. So, ang tawag doon sa action na ipa-file mo ay declaratory relief. Yan ang Rule 63. 63 of the Rules of Court. So, ito, ano naman na to? Yung procedure na. Kung gusto mo pang ipa-reform ang instrument, anong gagawin mo? You file a petition or a complaint under Rule 63 of the Rules of Court. Kwento mo doon kung bakit ka entitled sa declaratory relief. Okay, I think that's it for Reformation. Interpretation na. Interpretation. Sa interpretation, una sa lahat, kapag malinaw ang kontrata, ang terms ng kontrata, there's nothing to interpret. Malinaw siya. Ba't mo siya i-interpret? Nakalagay dito. First rule of interpretation, if the terms of a contract are clear, malinaw, and leave no doubt with respect to the intention of the contracting parties, you apply the literal meaning of the stipulations. Ba? Nakalagay doon, ibebenta ni X ang kanyang kotse, pulang kotse, Innova, Toyota Innova, na may plate number ABC123. Malinaw yun. Hindi mo sasabihin, pulang kotse ba talaga? O baka pink. Baka pink. Pwede rin pink o ganun ka pa. O baka naman ano yun, Avanza yun. Hindi Innova. Malinaw. Malinaw nga na Innova siya. Pula siya. Ba't mo sasabihin na malabo? Hindi nga malinaw. Buyer, si Y yung buyer. Si buyer ay magbabayad. Nag-agree siya na siya ay magbabayad ng 2 million. Ano gagawin niya? 2 million magbabayad. Baka 1.5 lang. 1,500,000. O baka 2,100,000. Huwag mong guluhin. No? Huwag kang mag-interpret. Ang linaw-linaw nung terms ng contract, then there's nothing to interpret. Just apply the literal meaning. Magde-deliver ng kotse, pula, Innova, ABC123, magbabayad ng 2 million. That's it. That's the terms of the contract. That does not model the... Huwag tayong manggulo. Huwag mong guluhin. If the words appear to be contrary to the evident intention, the latter shall prevail over the former. So ito again, napunta ka na sa interpretation. Meron nakasulat, pero yung nakasulat na yon ay nakakontra sa kanilang real intention. The intention will prevail. The intention will always prevail if it does not reflect the document. They can ask for the reformation actually, di ba? Pero depende kung ano ba yung naging dahilan kung bakit hindi nakasulat dun sa papel yung kanilang true intention. Kasi for the reformation, dapat merong ground. Diba? Nakalagay dito, mistake. Mistake ba? Fraud? Inequitable conduct? Accident? Yan. Kung yan yung naging dahilan kung bakit hindi nag-appear yung kanyang true intention, then you can ask for the reformation. If not, you can still insist yung intention dapat ang mag-prevail because that's the rule. The intention will prevail to the over what is written over in the instrument if they are contrary to their intention. Intention of the parties will prevail. 1371. In order to judge the intention of the parties, their contemporaneous and subsequent acts shall be considered. Sino yung intention, di ba? Sabi dito, the intention shall prevail. But intention is a state of mind. Ano bang gusto ninyo? Ano ba talaga ang napagkasunduan ninyo? Ano ang intention ninyong dalawa? That's state of mind. How do you judge the state of mind of two persons? That's abstract. Bulat-lakin mo yung mga utak nila to prove the intention. You cannot do that. Tanong pwede mong gawin? You look at their contemporaneous and subsequent acts. Kasi nagmamanifest ang intention. Di ba? Yung intention hindi siya mananatili sa utak mo. Tignan mo yung galaw nila. O, for example, hindi nakalagay lang doon that X will deliver a motor vehicle that he owns, which will be paid for by Y. Okay. With the price that they agreed upon. Kaya ikaw naman, di mo alam ano kaya yung motor vehicle. Napaka-generic. Then later on, si X nagde-deliver ng pulang Innova na may EBC 123 kay Y na tinanggap naman ni Y. So, ano, yun ba yung intention nila? Yes, because that is the manifestation of their intention. Although you know that X sold a motor vehicle to Y and you are not aware kung ano ba yun, but by examining their contemporaneous and subsequent acts, you confirm that their intention is to sell the red Innova X na ang red Innova ni X na may plate number na ABC 123. Pagmasdan mo at pag-aralan yung contemporaneous and subsequent acts. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intend to agree. Okay. May example dito. Okay. General. Yung agreement nila is general. For example, sabi niya, ibebenta ko sa'yo lahat ng motor vehicle. Motor vehicle na nasa aking garahe ngayon. Motor vehicle in the garage. That's a general stipulation. General terms, expressed in general terms. In the garage. Okay. For how much? For 5 million for everything, for every motor vehicle in the garage. Nagbayad ng 5 million. Oh, let's go to the garage. Pag open ng garage, may motorsiklo. Do you consider that? Yes. Because that is that thing is included in the term motor vehicle. May kotse, sama yon. Meron doon sa gilid, piano. May nakatangbak na piano doon sa loob ng garahe. Pinipilit nung buyer, sali yung piano kasi nasa garahe mo. Teka lang, oo nga, sabi ko nga, motor vehicle sa garahe. Yun lang. Though generic yung term na ginamit ko, motor vehicle, ang intention natin, yung mga motor vehicle lang. Huwag mong ipilit yung mga distinct and different from those which we agreed. Ito lang na pag-agrihan natin kung ano ng mga sinasabi mo dyan. Meron doon nakitang yate. Sama yun. It may be classified as a motor vehicle. May nakita doon ng mga libro. Hindi kasama. Motor vehicle. O kaya skateboard. Hindi motor vehicle yun. Kung ano lang yung magpo-fall under that generic term, yun lang ang kasama. Huwag mong ipilit yung iba. Okay? 1373. If some stipulations of any contract should admit of several meanings. May stipulation, pwede mo siyang interpret sa iba't ibang paraan. It shall be understood as bearing that import which is most adequate to render it effectual. Okay. So, mag-isip tayo ng example dito. So for example, meron silang agreement for, let's say, training agreement or tutorial agreement. Yun yung kasunduan nila. Nakalagay doon, si X, ang obligasyon ni X ay nakalagay ay magturo. Sila ay makikita, si X at si Y ay makikita para magampanan ni X yung kanyang obligasyon na magturo. So, nangyari, nakita si X na si Y, tinuturo ngayon ni X si Y. Sabi niya, ginaganong-ganon. Sabi ni Y, ba't mo ako tinuturo? Eh, nakalagay sa kontrata natin, magturo o tinuturo kita. Tama ba yun? Diba? Although, pwede. Kasi it admits of several meanings. Magturo. Pwede rin naman yun. Magturo. Point a finger. Pero, yun ba talaga yung intention? Or magturo as in teach? It shall be understood as bearing that import which is most adequate to render it effectual. Yung magkakaroon siya ng kwenta. Di ba nagkaroon kayo ng agreement para matuto si Y? So, paano matututo si Y kung duduro-duruin mo lang siya? So, para magkaroon ng effect, no? Para maging effectual, in order to render it effectual, we have to interpret yung magturo na yan as to teach. Diba? Kasi ito pwede mo itong i-interpret as to teach, magturo, to teach, or to point. Magturo din yan, turo. Sa alin dyan ang interpretation which would render it effectual? To teach. Alam mo, magkita tayo, bayaran pa kita para duru-duruin mo lang ako. Okay? So, ganun lang naman siya. Kung merong iba't ibang meaning, iba't ibang interpretation, kung ano yung interpretation which would render it effectual, yun yung kukunin. At hindi yung mga katuwa-tuwa lang. 1374. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Okay. For example, si X, ang kanyang mga obligasyon doon sa kontrata ay nakalagay to magdala, yung obligasyon niya dyan sa kontrata, magdala ng pako, magdala ng martilyo. So, dahil magdadala nito. At magdala ng pintura. Parang mga contractor sila. No? Tapos lang may itatay yung bahay. Si X, ang kanyang nakalagay din sa kontrata, magdala ka ng pako, martilyo at pintura. Okay. Dumating ang araw na sila ay mag-render na ng service, may dala siyang martilyo, may dala siyang pintura, tapos may dala siyang seaweed. May dala siyang seaweed. Ba't seaweed yung dala mo? Pako to pako. Sabi. Pako. Alam niyo ba yung pako? Seaweed. Ayan, pako. Nalagay siya sa salad. Pag nag-boodle fight, nakapag-boodle fight na ba kayo? May mga isda, may mga liempo, may kanin. Minsan may mga ganyan, may mga pako. Yan, dala niyo. Oo. Totoo naman, pako yan. Pero, isipin mo naman yung iba mong obligasyon. Magdala ng martilyo, magdala ng pintura, magdala ng ano bang paano mo na-interpret yan? Pako ba yan na pako na nails? O pako na seaweed? Isipin mo naman. You take them together. Kung hindi mo alam kung anong gagawin, pako kaya to o pako? Basahin mo yung ibang provision. Magdala ng martilyo, magdala ng pintura. Siguro yung pako na siguro hindi kami gagawa ng salad, gagawa kami ng bahay. Kaya pako ang dapat kong dalhin at hindi pako. Ganun siya. No? Ganun siya gumagana. Okay, that's 1374. Words which may have different significations shall be understood in that which is most in keeping with the nature of the contract. Example natin dito. Sabi, tayo ay, ikaw X ay mamimigay, ay XY, ating paghahatian ang tubo. Nag-agree si X at saka si Y na kanilang paghahatian equally ang tubo. So ano kaya ito? Letter A. Ito ba ay profit? Maaari. Tubo eh. Diba? Ito ba ay pipe? Paghahatian nila yung pipe? Tubo ng tubig, tubo ng tubig? O ito ba ay sugar cane? Ito ba ay sugar cane? So ano ba talaga ang paghahatian natin? Yung profits ba? Yung tubo ng tubig? O yung tubo ng asukal? O, tignan mo kung ano yung kontrata. Kung nakita mo yung contract, partnership pala. Contract of partnership. Malinaw. Partnership pala ito. So it must be, since the most in keeping with the nature and the object of the contract, since ang contract ay partnership, ang pinaghahatian nilang tubo dito ay yung profits. Hindi yung tubo ng tubig or tubo ng hindi yan or tubo na asukal, kundi tubo na profits. You look at the nature and the object of the contract. 1376, usage or custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract and shall fill the omission. So for example, you entered into a contract of sale for the fruits of a tree. So nasa puno pa siya, tapos andyan pa yung mga bunga. Nagbayad ka na, pumunta ka na doon, pero hindi naging malinaw kung sino yung kukuha ng mga bunga. You fail to agree. It is not, you did not agree to it, pero paano na yan? Nagkabentahan na tayo. Kailangan kong makuha yung mga bunga na yan. O, pag hindi napag-agrihan yan, magtanong-tanong ka dun sa usage or custom of the place. Paano ba yan, ano ba ang kaayusan dito sa lugar ninyo? Yung bumibili ba ang pipitas ng bunga? O yung nagbenta ang kailangang pumitas ng bunga? Kasi iba-iba yan. May ibang mga lugar, kung sinong bumili, siya yung mamimitas ng mga bunga. May ibang lugar na kung sino yung nagbebenta, siya yung magpipitas ng bunga, maglalagay sa mga sako para ready ng kunin ng buyer. Iba-ibang lugar. So, you ask for the usage or the custom in the place kung nasan kayo pumasok sa kontrata. Okay. The interpretation of the obscure words or stipulation shall not favor the party who caused the obscurity. Again, in here, you have the innocent party and you have the guilty party. Parang sa Reformation, ang pwede lang ang paborableng interpretation ay mapupunta kay innocent party. Kung ikaw yung guilty party kasi ikaw yung nagdulot ng obscurity, yung pagiging malabo ng kontrata, magsasuffer ka. Since you were the one who caused the obscurity or the doubt, then the interpretation which is not favorable to you will be given or will be used. Doon tayo magpapabor sa innocent party, doon sa victim tayo papabor. 1378. When it is absolutely impossible to settle doubts by the rules established in the preceding articles and the thus refer to incidental circumstances of a gratuitous contract, the least transmission of rights and the interest shall prevail. If the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interest. If the doubts are cast upon the principal object of a contract in such a way that it cannot be known kung ano talagang intention nila, it shall be null and void. So kapag ang kalabuan ay nasa principal object na, it is as if walang object. They fail to agree upon the object. There is no meeting of the minds with respect to the object. Kulang ka na naman ngayon ng essential elements. Pag kulang ng essential elements, ano ang effect? Null and void ang kontrata. So, doon tayo sa una. Ito madali lang to kasi talagang malabo yung kontrata ninyo. Kahit anong gawin natin, never natin makukuha o malalaman kung ano yung principal object. At dahil wala talagang mapagkasunduan, null and void na yun. O dito sa una. O doon tayo sa gratuitous. Pag sinabing gratuitous, walang kapalit. Onerous, may palitan. May exchange of values. For example, dumating sabi ni X kayo, may emergency. Sabi ni X kayo, why emergency? Yung asawa ko manganak na. Manganak na? Ano itutulong ko? Sabi ni Y. Hindi gumagana yung kotse ko. Baka pwede yung kotse mo. Sige, kunin yung kotse. Pag-drive mo, pag-drive. Hindi yan na. Tumating na nadala ni X yung asawa niya sa hospital, nak, etc. Tapos na. Wala nang problema. Naitawid ang problema. Ngayon sabi ni Y, sa akin na yung kotse ko, binabawi ko na. Sabi ni, di ba binigay mo na sa akin yun? Anong binigay? Pinahiram ko lang yun. Hindi, binigay mo na sa akin. Wala akong naaalala ang sinabi kong binigay. Hindi, sabi mo, kunin ko na eh. Quote unquote, kunin ko na eh. Para madala ko yung asawa ko sa ospital eh. Oo nga, sabi ko kunin mo na, pero kunin mo na meaning pahiram. Hindi, kunin mo na meaning donate. Dalawa ngayon yung ibig paano niya, parating niya. Ano daw ba ibig sabihin ng kunin mo na? Pahiram ba yun? O bigay? Dahil yung pagpipilian mo ay parehas na gratuitous, ang pahiram ay gratuitous, ang bigay ay gratuitous, ano ang gagawin mo? Ang pipiliin mo ay yung least transmission of rights. Alin dyan ang mas kokonte daw ang matatransmit na karapatan? Alin dyan? Yung pahiram lang. Hindi siya bigay. Pahiram lang yan. Hindi yan bigay. Yun yung ibig sabihin ng una. Dito sa pangalawa, if the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity. Nagkabentahan. Libro, for example. Book. Si X na si Y. Si X nagbigay ng book, nag-deliver ng libro, ang value, for example, 1,000. Okay. Si Y, nag-abot kay X ng 1,200. Sobra. Sabi ni X kay Y, sabi ni Y, teka lang, sobra pala yan. Akin na yung 200. Sabi ni X, hindi. 1 to 2. Hindi, 1,000 lang. 1 to. Magkano ba yung libro? 1,000. Alam ko, 1,000, pero 1 to yung napag-usapan natin. Ba't naman ako bibili ng libro na alam ko ang value 1,000 tapos 1 to ibabayad ko? Hindi, yun talaga. Hindi na sila hindi nila alam ngayon, 1,000 ba o 1 to. But they agree na itong libro na ito ay worth 1,000. 1,000. Onerous yan. Tapos may doubt kung 1,000 ba talaga o 1 to. Sabi, it shall be settled in favor of the greatest reciprocity. Kung saan sila magkakatagpo doon sa presyo. At magkano yan? 1,000 lang. Yun yung greatest reciprocity. Hindi pwedeng 1 to. Ibig sabihin yung palitan dapat magpantay. Kung ang binigay ni X ay libro with a value of 1,000, dapat ang mag-give up din ni Y ay 1,000 lang din. Kasi yun yung greatest reciprocity. Kasi pag 1 to yan, hindi na siya reciprocal. Hindi na nag-reciprocate yung mga values. So hanggang 1,000 lang siya. Kasi up to 1,000 ang greatest reciprocity of interest. Okay, I hope malinaw yun. 1379, you also look at the Rule 123 of the Rules of Court. Meron pa daw mga additional and similar rules of interpretation. Okay, so that's it. Yung next article ay resiscible contracts na, which are the defective contracts, yung start na defective contract. So, konti na lang, matatapos na to. For the next video, I will continue with resiscible contracts. Until then, thank you for listening. See you on the next video.